Hello. You might be wondering why I'm sitting in my car if this isn't a barking while parking or a jiving while driving. It's because I got this. I don't know. Hopefully you can read this. Pause it if you can't. Do. Maybe you can see it all there. There you go. All right, this is from Mega Million. And this just is going to go show you guys what I mean when I say people, they just don't understand the law and they think they do and they're retarded. And they don't even realize they're retarded. He says, Merb, once again, you're wrong about the law. This is going to be fun. Earl's polygraph test can certainly, capitalized all the whole word, certainly, so it has to be true, be admitted into evidence in his trial. He's certain. Polygraph tests are not admissible by the government, all in caps. If a defendant objects, it's not admissible by the government if the defendant objects. However, defendants are absolutely allowed to enter them into evidence in various ways. Oh my! The most sound way is to support testimony given by the defendant if he so chooses to testify. Come on, Merb, learn some criminal law and trial law. Well, I am not a criminal law and trial law expert. Trial law. I think he meant procedure. Criminal procedure. Yeah, I'm not a criminal procedure expert, and I'm certainly not an expert on the criminal procedures in Texas. But I am a first-year family law attorney. This is the cover page. I don't know if you can see it. It's in the Court of Criminal Appeals of Texas. That is the highest court in the state of Texas. It is number PD-0551-10. This is William Thomas Leonard, appellant v. the state of Texas. There are two. So just so you're aware, this is the one from November. There's also a previous one from March, something like that. But that one was replaced by this one. They both held basically the same thing, but there is a little bit of difference. I'm going to start, I don't know if they even have page markers on this. If you go to Court Listener and you download the document, it's going to be on starting on page 6. I don't know if you could read it, but there's the URL that I downloaded it from. You can find it at other places too. The history of this court's dealings with polygraph evidence is long, but not very complicated. For more than 60 years, we have not once wavered from the proposition that the results of polygraph examinations are inadmissible over proper objection because the tests are unreliable. So this also goes, by the way, to whatever that one that Earl cited that said that they're reliable. It's not that they're not reliable. It's that they're replacing the jury. No, it's both, dude. But what do I know? First-year family law attorney. Our first discussion of the reliability of lie detector tests was a passing note in McKay v. State. In that case, a defendant charged with driving while intoxicated challenged the admissibility of a Harger drunkometer test showing that his blood alcohol level to be 0.27. After we affirmed the conviction, McKay asked for a rehearing as examples of appellate courts disallowing scientific evidence when scientists were not generally agreed. When scientists were not generally agreed. There you go. Regarding the reliability of the evidence, he cited several cases from other states holding that lie detector tests were inadmissible. Though the issue of lie detectors bore little relation to the case then before us, we stated that we were in accord with such holdings, and until such tests can be shown to fairly show the guilt or innocence of an accused, we see no reason for their introduction into evidence. In Peterson v. State, we weighed in on the admissibility of lie detector results in a more relevant context. In Peterson had sought to call as a witness one D.E. Wheeler, the operator of the Keeler polygraph or lie detector machine for the Texas Department of Public Safety. In order to have Wheeler testify as to the facts observed by him in the giving of such tests to the defendant. The trial court had excluded the testimony because the facts concerning the test would invade the province of the jury and constituted a mere expression of opinion as to the guilt or innocence of the defendant. Though we held that the appellant had not properly preserved the matter for our review, we went on to note that this court has not yet authorized the admission of such evidence on behalf of the state, and until this is done, it cannot be admitted on behalf of the defendant. Several cases over the next decade cited back to this apparent dictum in Peterson as a holding of the court. In Stockwell v. State, after determining that there had been enough evidence to require the trial court to hold a hearing on juror misconduct, we noted that the misconduct in the case, reading a newspaper article that implied the defendant had failed 4 lie detector tests, was particularly harmful because lie detector results were inadmissible. In Davis v. State, we held that the trial court erred in not granting the defendant a hearing outside the presence of the jury regarding the voluntariness of his confession. After the trial court had denied Davis's motion for a hearing, he had presented the evidence of the voluntariness of his confession, including the fact that he'd failed 2 polygraph examinations, to the jury. At the end of the opinion, we noted that we were not condemning the use of the polygraph as a means of interrogation, but upon another trial, the testimony which in effect revealed the results of the polygraph tests should be excluded from the jury. In Packer v. State, the defendant had tried to admit evidence he had taken and passed a polygraph examination. Citing to Peterson, Stockwell, and Davis, we reaffirmed that evidence of the results of a polygraph test is not admissible on behalf of either the state or the defendant. Do you notice a theme? It was not until 1964, 23 years after the invention of lie detector tests began appearing in our cases, and 12 years after our statement in Peterson, that we had occasion to rule on a case where polygraph evidence had been admitted over objection. Nichols v. State was an appeal from a conviction for statutory rape. After defense counsel rather extensively cross-examined the complaining witness, on redirect, the prosecutor asked her, "Without telling me any results, did you take a lie detector test about this?" As defense counsel objected, the witness answered in the affirmative. The trial court instructed the jury to disregard, but it did not rule on the defense motion for a mistrial. On appeal, we found, without a single exception, that every court of last resort that has been called upon to decide the question has ruled that results obtained from the so-called lie detector tests are not admissible as evidence. Even though the trial court did not deny the motion for a mistrial, we held that it was error not to have granted it because the prejudicial effect of admitting the results of a polygraph examination was such that no amount of instructions on part of the trial court could remove from the jury the harmful effect created in their minds. Oh, that was from no amount of instructions on the part of the trial court could remove from the jury the harmful effect created in their minds. 9 years after Nichols, we issued our most important and thorough opinion on polygraph evidence. The defendant in Romero v. State had entered into a signed agreement with the state that he would take a polygraph examination, and the results, whatever they showed, would be admitted at trial. After he failed the examination, the defendant objected to the admission of the results, claiming the state had violated the terms of the agreement by giving him methadone shortly before the examination by using an unqualified polygraph examiner. The trial court admitted the polygraph results over this objection. Aside from the polygraph examiner's testimony that the defendant gave deceptive answers regarding his role in the offense, the only evidence against the defendant came from accomplice testimony. We began our discussion of polygraphs by noting no machine or device has perhaps caused greater controversy among experts, judges, lawyers, physicians, psychologists, government officials, and the public in general than the polygraph or lie detector machine. In comparing our cases barring admission of polygraph results to those of other jurisdictions, we noted our rule followed the almost unanimous view of American courts, and most American courts don't allow lie detectors. I think California does, but I haven't dealt with a polygraph in California yet, but I think they do. We then listed several potential problems with polygraph examinations that might distort the results, such as the test subject's emotional tension, physiological abnormalities, mental abnormalities, unresponsiveness, and unobserved muscular movements that produce ambiguities or misleading indications in the blood pressure tracing. Additionally, we noted several potential problems that were unrelated to the test subject, such as potential errors by the examiner, the lack of standardization in procedures, the difficulty in jury evaluation of examiners' opinions, and the tendency of the trier of fact to treat polygraph evidence as conclusive. Although he noted that our bar on polygraph evidence had received some criticism and that at least 2 federal district courts, one of which was later overruled, had admitted polygraph evidence, we concluded that these authorities were insufficient to overcome the unreliability of polygraphs. While we are aware of efforts to promote the reliability of polygraph tests and the claims that they are now more reliable than before, we are convinced at this time we should adhere to the general rule of exclusion. But would a stipulation between the parties be sufficient to allow the admission of otherwise unreliable evidence? After citing 2 opinions from other jurisdictions, we agreed with an opinion of the Alaska Supreme Court that regardless of what the parties agreed to, it was our duty to keep unreliable evidence out of trials. A stipulation for admission does not increase the reliability of polygraph results and therefore should not lead to any deviation from the exclusionary policy. On that basis, we reverse the judgment of the trial court. Romero was the last time we examined in detail the science and jurisprudence surrounding polygraph examinations, and in the 39-year since, we have never departed from its holding. And Rule 703 and reliability. 5, Rule 703 and its reliability. I guess this is part 5. In the first 4 issues, the state argues that while polygraph results are inadmissible on their own, an expert who testifies under Rule 702 may, according to Rule 703, base his opinion on inadmissible evidence, and under Rule 705 inform the trial court for the basis of his opinion. So in this case, it would have been permissible. This is all not really relevant. But Rule 703 does not render the opinion admissible. Thus, Rule 703 does not provide a basis for the trial court to admit Strain's testimony, and we overrule the state's first 4 grounds for review. All right, the show no deception provision. In its final ground for review, the state argues that the Court of Appeals erred by stating the polygraph results could be admitted even to litigate the provision in the appellant's probation condition requiring him to take and show no deception on polygraph examinations. The requirement that appellant show no deception on the polygraph, however, strikes us as questionable. At the very least, we do not believe it prevents a sufficient basis to compel the admission of polygraph results. Now, there may be a change in the statute in Texas to allow for polygraph evidence in probation and things like this, sexual misconduct cases where they're out, but they have to continually take polygraph tests. I believe the results of those polygraphs by statute are allowed, but I could be wrong on that. I haven't researched it, not really applicable. The Court of Appeals cited to a string of lower court cases where taking a polygraph exam was a term or condition of community supervision, and the state directs us to a lower court opinion that held that a trial court was within its discretion to require polygraph examinations as a condition of community supervision. However, the court in that case, after stating our rule that polygraph results were inadmissible, noted that the polygraph condition at issue was imposed not to gather evidence for use during trial, but solely to serve as a catalyst for future investigation. One of the suggested terms of community supervision, blah, 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 polygraph examinations were completely accurate, requiring that the plaintiff show no deception might make sense. As we discussed in Romero, though, there are several potential sources of error in polygraph examination, few, if any, of which are within the test subject's control, blah, blah, blah. The trial court may impose any reasonable condition of community supervision that is designed to protect or restore the community, protect or restore the victim, or punish, rehabilitate, or reform the defendant. Whether requiring the appellant to submit to a polygraph examination is a reasonable condition is an issue we are not called on to decide today. What we decide is that any such requirement does not justify admitting legally unreliable evidence. In conclusion is, because the trial court adjudicated the appellant guilty based on the third party's exercise of discretion, we must look at the basis for the underlying exercise of discretion. Here, the only basis for the third party's decision was the results of polygraph examinations. We hold that Rule 703 does not allow an expert, blah, blah, blah. So anyway, my point is, as they went over in detail, as subsequent cases have gone over in detail, in Texas, polygraph results are not admissible in court. They're not admissible by stipulation. They're not admissible by the defendant. They're not admissible by the state. So, Mr. Mega Million, you're retarded. you should probably stop and consult an attorney before you try to think of any legal advice to give. So thank you for watching. I appreciate you sitting around for the duration of this. I apologize for how long it was, and have a great day.